My name is Maneo Mohale, and together with Iranti-org, we created a 5-part conversation series about the draft Prevention and Combating of Hate Crimes and Hate Speech Bill. I sat down with various stakeholders, academics, and activists to discuss and unpack their views about this controversial and contentious bill. The aim of this series is to increase public awareness about the bill, but more importantly, to increase public engagement with the bill. In this interview, I speak to Professor Juan Nel, who is a co-founder of the Hate Crimes Bill Working Group. Professor Nel, in this interview, gives a little bit of insight into how the bill came about, especially highlighting prominent and precedent-setting cases around hate crimes. Professor Nel also gave us insight into how the bill potentially differs from existing forms of legislation, as many critics of the bill point out or ask the question about how this bill would differ from existing forms of legislation such as PAPUDA, etc.
My relation to the area of hate crime is that I've been a founder member of several of the structures that have been instrumental in getting the government response where it currently is with a draft bill on the table. In particular, I was instrumental in getting the victims of hate crime identified as a priority target group for inclusion in the Department of Social Development-led policy framework for victim empowerment and support. And that dates back to 2009, and then I'm also a founder member of the Hate Crimes Working Group, which is a civil society network that brings together people from the LGBTI sector, non-nationality, religion, disability, race, etc.
Also, if you could give us an idea of how the hate crimes bill, as we currently see it in its current form, what was the process involved in getting it to the document that we see today, the draft document that we see today?
If my memory serves me well, there was a first appeal to government from the South African Human Rights Commission in 2003. And we know that, of course, the Human Rights Commission is also the custodians of PAPUDA, the Promotion of Equality and Prevention of Unfair Discrimination Act. So indeed, the appeal coming from them that we need better measures in this regard is a very important one. And they repeated that, I think, in 2008, and if I'm not mistaken, 2015 again. Some NGOs in the mainstream, like the Center for Study of Violence and Reconciliation, brought out a very useful document in 2004 around arranging the hierarchy of prejudice, which was specifically about hate crime, and making an appeal that we don't have a hierarchy in terms of what we view as vulnerable groups and where a response should be. So it was an attempt at connecting dots. A few cases that went to court, and where indeed the appeal was on the court to identify the hate motive. The first that really caught a lot of international attention was Zoliswa in Guyana, 2006, murder Kalicha. And before I forget to return to Zoliswa, it took 6 years, more than 40 postponements before there was a conviction. And if it wasn't for Triangle Project putting all of the time and all of the emotional resources into that process to keep the criminal justice system to account, we'd have never had a conviction. And that's also the first time the hate element was ever acknowledged in any criminal procedure. So it's truly a very important case. And the last case I'm going to mention is UDC Milano, which dates back to 2007 as well, I think. And although there was quite a rapid conviction in that instance, 2009, yet again, the hate element was not acknowledged. But then very briefly, just in terms of other factors that played a role, CERD, so the Committee for the Elimination of Racism from the UN, made an appeal to our government in 2005, I think it was, that indeed there should be a more concerted effort to protect vulnerable LGBTI people. And of course, the hate crimes working group was formed in 2009, and our first submission to government was in 2010. So there are a few others that I could mention, but, well, it might be important to mention that with lots of national and international pressure, our government finally put together the National Task Team, which responds to LGBTI vulnerabilities for crime and violence.
Okay, yeah. Well, thank you so much for such an expansive sort of summary of the immense sort of work that goes into the bill, and it really helps contextualize why it is that we have the document that we have. You mentioned hate speech. I really want to hear your thoughts. That a few, quite a number of critics on the bill have wondered about the inclusion of hate speech along with hate crimes in the legislation. So I was wondering what your thoughts are on that inclusion.
So I'm going to give you the official hate crimes working group position. You'll be aware that the closing of public consultations around the draft was on the 31st of January. And in our submission to the Department of Justice, that's the one aspect that we strongly oppose. And the hate crimes working group truly doesn't believe that the criminalization of hate speech is in the interest of this piece of legislation for a variety of reasons. But our main concern is, other than of course the legal challenges that will follow and the difficulty to implement such an inclusion, it's also because it will undoubtedly delay the passing of provisions for hate crime, which we do believe is an absolute urgent priority, and really the LGBTI sector, but also the other vulnerable groups cannot afford a delay in that regard. But I'm wanting to immediately also say that the fact that the hate crimes working group opposes the inclusion of hate speech does not at all imply that we don't deem hate speech as very serious and the damage done considerable. Indeed, the psychological harm done by hate speech is significant. But certainly we would not be pushing for the criminalization of hate speech. Indeed, we think that the provisions of, or the protections provided by the PUDA needs to be strengthened considerably.
We have legislation, we have existing tools and instruments that seek to bring people that commit hate crimes and have utterances of hate speech to task and bring them to justice, as well as giving the survivors and victims of these crimes justice. So I think that if I'm understanding the critique is they ask, well, what is this new bill going to do if we have existing legislation that hasn't necessarily proved to be a deterrent to these kinds of crimes? What are your thoughts on that?
Unfortunately, we know that to have a law is one thing and to implement it is a totally different matter. And there's so many pieces of legislation where the implementation has been truly very disappointing. So not for a moment do I want to even pretend that I think a law is going to make all the difference. And furthermore, the way that I understand the law, the fact that something is acknowledged in legislation allows for a policy response, allows for resource allocation. So at this stage, the amount of resources made available to prevent and appropriately respond to hate crimes is minimal. If we have a law that acknowledges that hate crimes happen and they happen across all of these vulnerabilities, then indeed there will be more resources to do the prevention work that is so much required. So those are a few of the the differences. And indeed, the last thing I perhaps want to mention in terms of the distinction between PAPUDA and then, of course, a hate crimes bill such as this. The one is a civil remedy, this is a criminal remedy. And the civil remedy provides for a whole range of restorative justice measures. The criminal remedy, as it is currently, does not provide for restorative justice measures. And whether that's a shortfall or not is another debate. I personally like restorative justice measures, but indeed there's been lots of arguments on the table that we don't want to run the risk of minimizing the seriousness of these kind of crimes. So indeed that's a fight for another day, to make sure that indeed restorative justice measures could be built in as well.
Thank you so much. Thanks so much for sitting down with me and for giving such a perspective, such a detailed perspective on the bill.
More than welcome.
Thanks.
Thanks, Maneo.
Thanks.